That was District Attorney Karen McDonald telling the court the details of the overwhelming response at the Oxford High School after that deadly mass shooting incident. The accused in this case is only 15 years old, Ethan Crumbley. He's being charged as an adult and is facing multiple counts of murder, terrorism, and other crimes in the shooting deaths of 4 students and injuries of 7 others, which included 1 teacher. Just hours ago, Crumbley had another court appearance, this time for his arraignment. Let's take a listen to a portion of that hearing together.
Today's date and time set for an arraignment. Ms. Lofton?
Yes, Your Honor. I would waive the formal reading, stand my client mute, ask that a not guilty plea be entered.
Thank you. The court will accept jurisdiction, enter a not guilty plea on behalf of your client.
Tamara A. Walker, criminal defense attorney, still with us. Let me first ask you, let's just boil this down to the basics, because that was a very short hearing held remotely today. So number one, how would you define or describe what an arraignment is?
Well, an arraignment is a very preliminary procedure. It's at the beginning of the process. And to boil it down to the lowest terms possible, it's where a defendant enters a plea of guilty or not guilty. That's it. So today what happened was their attorneys entered on his behalf a plea of not guilty, and he decided to not say anything else. And at that point, the case then proceeds on to trial.
And it's an opportunity for the court to set dates, to do a roadmap, to make sure everything is adhered to. I would argue a time for the defendant's constitutional rights to be protected for speedy trial and all the rest that apply. So typically, do you waive reading of the charges for your client? And if so, tell us why, because that is what happened in this hearing about Ethan Crumbley.
Right. Here in Cook County in Chicago, that is what myself and most defense attorneys do, simply because at the time of arraignment, you typically have already received a copy of the indictment or the charging document. And what that is it tells the person what they're charged with. It has what the penalties are in terms of what the class of the offense are. And so by the time you go to the arraignment, you and the client have already discussed at length what the charges are, what penalties they carry, what class offense they are. So to have that formal reading by the judges is typically not needed.
Right. It's not often seen here either in my experience, but again, pointing out across the nation, things are done differently in different courts and in different practices by attorneys. Let me ask you, your own experience, I know that you represent Jussie Smollett, lots of other criminal defense cases. How has COVID impacted trying cases, and do you think that it has had any direct result on the rights of defendants?
You know, that is a great question, Ashley. Thank you for that question. And thanks for having me back, too, while I'm at it. So absolutely, the impact on the court system has been tremendous. Obviously, as the pandemic, in the early days, really reached critical mass, courts were shut down. Then when some things were reestablished, obviously some of the bond things had to always take place. You moved to a remote scenario, and that was problematic at first. I think we've worked out a lot of the kinks out of that at this point. But at this point, having an in-person trial, just like with the Halderson case, it is just fraught with issues that could potentially occur, namely one of the parties being testing positive for COVID-19. I mean, that's the absolute worst case scenario. Very thankful that did not happen during the Smollett trial. But, you also have the issue of jury members and childcare. I mean, here in Chicago, we just had 5 days where our children, my children included, were not able to attend school because the Chicago Teachers Union decided to take a stand and wanted some more safety precautions in place. So it is literally a minefield of all sorts of issues, and it's been definitely problematic.
And one of the things that I think is clearly, just given the timing in it and that it's still an issue, we don't yet know what issues might be appealed, nor do we know what appellate courts might do about those issues. So I think that's going to be a long-term effect that we're just going to have to wait and see. I also want to talk about something else in the Ethan Crumbley trial, because there are new documents of a lawsuit. Now, this has been brought by parents of one of the surviving victims against the Oxford Community School District. And really, this lawsuit lawsuit reveals some disturbing new allegations. The amended lawsuit alleges, for instance, that on November 11th of last year, Ethan Crumbley brought a severed bird head in a mason jar containing a yellow liquid into the school and left it in the boys' bathroom. Students reported that to the administration. And although it was reported, the school chose not to address it. They decided that it was not a threat to the school or the students. The lawsuit also alleges that on the day before the shooting, Ethan brought live ammo into the school and openly displayed it while in the classrooms, which teachers also disregarded. Tamara, are those threats from your perspective? Let's start with the bird head in a mason jar with liquid left in a boy's bathroom. Threatening or not from your perspective?
Absolutely threatening, absolutely something that should be followed up on by teachers and administrators. I believe that it's well known that one of the indicators of someone with psychotic tendencies or problematic or violent tendencies, especially in childhood or teenhood, is violence towards animals. And, obviously, I guess perhaps their counter argument was that, this is a place where we do dissections in science, that type of thing. But to have an isolated child who takes that upon himself to do violence to an innocent animal and then leave it on display, that's problematic. And I feel that that's something that should have been referred to a counselor or someone with experience to see what types of needs needed to be addressed.
Because
same thing with, oh, I'm sorry, go ahead.
No, I didn't mean to interrupt. I want to stop there for just a minute, and then I want to hear about the ammunition piece, which is another issue in and of itself. But I still stand by, even if the school felt that the head in a jar was not necessarily a threat to other students, I think it's a good sign, red flag, threat to that own student, because
Absolutely.
To your point, when they start engaging in that behavior. All right, I accidentally rudely interrupted you. Now tell me about your take on the ammunition.
Well, I appreciate the break. I probably needed it. But yes, the ammunition is even more problematic. And as you well know, Ashley, when you're looking at someone who's unlawfully in possession of a weapon, the ammunition carries a charge as well. It's similar to a weapon. So I cannot fathom what was going on with those teachers and the administrators, if administrators didn't know about it. But certainly the teachers not to have sent that up the flagpole to hire administrators to make a decision there. That is very troubling. And had my child been a victim of that definitely would be looking at further action.
I think one of the things that sounds distressing, according to the allegations in a lawsuit, and again, this is a lawsuit against the school district, nothing's been proven at this point in time, but the allegations are that parents and students went to the school administration about these various things, and that the school did send correspondence via email to parents saying, not a threat to the school, not a threat to the students. So have they put themselves in any type of really bad place in terms of they've made it their affirmative duty? They actually, it's not that they didn't respond. They did respond and said, oh, there's no threat, only for the school to be shot up and 4 people are killed.
Right. Absolutely. Not only did they take that type of position, but what's more troubling to me is that they did nothing about it. I mean, you have someone who's at least exhibiting signs of being troubled, having mental issues. It could be nothing, but it could be, as it was in this case, it could be something where now you have children who are deceased. I mean, that is the absolute worst case scenario. And they most definitely dropped the ball, to put it lightly. Taking that type of position is, as we can see, dangerous.
And not only the death of children, but the death of children when they're at school, which is, I think, one of the very last places in our society that there used to be an assumption and a knowledge that your children were safe. We are covering a lot of passionate cases today because the next one we're going to talk about is Harmony Montgomery. This is the 7-year-old child that hasn't been seen in more than 2 years. And we have a very special guest who's going to be joining us. We'll have an interview